go outside. We had to find ways to busy ourselves. We had to do things outside so we didn't break anything inside and get in trouble. So what we end up doing is my brother and I would go outside and we'd start throwing the football around for a little while. We tossed the baseball around for a little while. Then we would start running around her house because my brother was older, so I tried to catch him. So we try to run around and see if I got any faster than he. At some point in time after lunch, we would make our way to this makeshift barber shop that my grandfather had built on the side of the house. And we'd sit down and we'd listen to the old man playing checkers, trying to pick up on some words we probably shouldn't have been hearing. We'd hear him slapping the checkers on the board, saying "king me" and all that kind of stuff. And we'd be learning some old man stories as kids. It was fun. We'd sneak into a little side of the barber shop and try to get his red man shoe. And the joke was we try to put a little piece in our mouth and try to hold it in there as long as you could before it burned a hole in your mouth. But we try to hold it in there and try to see who could hold it the longest before you started gagging. This mischievous stuff that kids do. That's what we did. But at the end of the day, every evening, my brother and I would end up on the front porch. And my grandmother had a set of rocking chairs out there. And we would sit in those rocking chairs and start playing what I call rocking chair games. The first game, we'd sit down and then we'd try to see who could rock the fastest. I'm sure some of y'all have done this. Then we try to see who could rock the fastest and the farthest with your legs in the air. It's good ab work if you need to do it. But trying to go back and forth and see how fast you can go with your legs in the air. And inevitably, the last thing that my brother Chris and I would do, we'd sit down and we'd rock the chair as far back as you could go without it falling over. And we'd do that. And we did that over and over and over. One evening, my grandmother came outside and she saw us standing those rocking chairs up on edge. And we knew we were in trouble. Again, this is the 70s, early 80s. This is the day of knockouts, not timeouts. We knew we were about to get in trouble. But my grandmother said something to me that stuck with me and it still rings in my head today. She said, the funny thing about rocking chairs is that they'll keep you busy, but in the end, they don't get you anywhere. The funny thing about rocking chairs is that they keep you busy, but in the end, they don't get you anywhere. Ladies and gentlemen of the jury, Mr. Kent, Mr. Swirler, Mr. McCullough, and that team over there has kept you busy with all of this stuff. But at the end of the day, the question still remains, what is the value of a human life? They have kept you busy with these insinuations that Cyrus was some young thug, some thug in training, running around Columbia, their words, with a loaded pistol, an empty backpack, and no money. Their words. They have kept you busy with this insinuation that this case has to be about and is only about, and is mostly about, a 14-year-old carrying a gun. We keep talking about why do 14-year-olds have guns? Why do children carry guns? Of course, let's be abundantly clear. Cyrus should not have had a gun, period. No question. Nobody at the state stable has suggested that he should have. So let's put that aside for a second as we talk about what this case is really about, because he shouldn't have had a gun, no question. Question, are we still having this conversation if Cyrus is 24 years old, if he's 20 years old, if he's 34 years old, 44 years old? Are we having this conversation? Somebody wrongfully accused of stealing, chased out of the store after they tried to de-escalate everything that they could, running, falling down, running out of your chute, tripping, dropping phones, running farther, falling, busting your shin, gun spills out, you're still running. And according to the testimony that you heard from this chair, grown man, Andy Chow, state championship swimmer, 185 pounds, 200 pounds, about 85 pounds more than Cyrus, was right on top of him when he fell. And Dad was close by, in arm's distance. That's what the testimony was, not all this stuff. He was right on top. Question: as you listen to the elements of self-defense, not bringing on the difficulty, who would have had a claim of self-defense in this case? Cyrus. Being chased by two men armed with a gun on top of you after you've run 130 yards. Folks, I submit to you, as I'm walking from that tip back here, you get to the end of this corridor, that's 20 yards, 19 yards. Times 5 plus 30 more yards. That's how far he was chased. So who would have had a self-defense claim? So I'm suggesting to you that they keep insinuating these things, saying these things, because they don't want you to think about it. Again, I mentioned to you this to you multiple times. When you parked your cars, you didn't leave your common sense in the parking lot. Take it with you. Think about these things. Don't let them sway you with all of this mess and all this other stuff that takes us off of what the real issue in this case is. Don't let them do it. The defense kept weaving this narrative, again, that Cyrus is some young thug walking around the streets of Columbia, again, with a loaded pistol, no money, and an empty backpack. I submit to you that, folks, if Cyrus was this thug that they keep telling you that he was, by showing you pictures and trying to get you thinking in that direction, we never would have gotten 130 yards down the road. He would have held court right at 7441 Parklane Road. Cyrus would have been the judge, the jury, and the presenter of the sentence right there in that spot, if he was the thug that table wants you to believe that he was. But instead, what were his actions? Folks, he ran. He ran like a child. He ran from the adult. Let's think about who acted like the thug, the gangster. The person who chased him down the street, or the person who ran while he had a gun hidden. He ran out of the chute. How do we know that to be true? Because we see it on camera. Shoe flies up in the air, and he keeps running. Doesn't stop. Turn around. I want to drop my shoe. Let me get that, because I'm going to get in trouble if I go home with one shoe. He didn't do that. How afraid do you have to be to run out of your shoe and not turn around to pick it up? Find on that. He ran further. Phones fell out. They keep coming to you with this mess that, oh, he threw his cell phones out. What sense does that make? Did you leave your common sense in the parking lot, or did you bring it with you? How afraid do you have to be to drop 2 cell phones and keep running? Again, let's be very logical about this for a minute. 2 cell phones. We know how expensive they are. One cell phone belongs to you, and the other belongs to your mother. Do you mean to tell me that you are going to go home that day with one shoe and tell your mother, Mama, I lost my cell phone and yours too, and I didn't turn around and get it? You want that smoke? You really want to get what you would get if you lost 2 cell phones from your mother? But you know why he didn't turn around? Because he was scared. Because that man, armed with a .45 caliber pistol, and his son were chasing him for no reason down a road in South Carolina. Chasing him. Didn't turn around. Kept running further. Fell again. Hard. Dropped the backpack. And by the way, since they want to keep saying it was empty, actually had some personal effects in it. There was an address in the backpack. Really? Fell. Dropped the backpack. Didn't stop and say, oh, stop, guys. Let me go get my backpack. Let me go get the phones. Let me go get the shoe. Kept running away from them. Is that a thug? That's a kid who was scared of 2 grown men, running as fast as he could, as far as he could, trying to get home. But they wouldn't allow it. They would not. For some reason, they could not allow it. And then, at some point, as he fell hit the ground, that gun comes out, that tack light comes up. Now, I'll suggest to you, as Mr. Kent talked, he keeps saying, well, he was picking up the gun and he was pointing the gun, all that kind of stuff. Stop, just stop. Because what we say is not evidence. I told you before, the evidences will come from this witness jury. There were 4 eyewitnesses who were not named Chow. Which one of them ever said they saw Cyrus Carmack-Belton point a gun? Which one? Which one? No. 4 of them. 3 different vantage points. Lori Carson, Kennedy Carson, mom and daughter. They told you they watched and they saw a straight line of what happened. Cyrus ran, fell, hit the ground, got up running, and that's when he was shot. Asked multiple times, well, did he turn at them? Did he point at them? Did he do anything? No, we never saw anything in Cyrus's hands. 2 witnesses, mom and daughter, vantage point at the front of the store. Didn't see any of that. Any of that. Devontae Bryant, driving, white Honda, threw on brakes so he wouldn't run over anybody as they ran in front chasing Cyrus. Asked as he rode by, did you see him point anything? Cyrus Carmack-Belton point, stop and point. No, he didn't. He didn't have anything in his hand. His book bag fell. He was flat. He fell hard. His hands were on the ground. He got up trying to run, and that's when he was stumbling again and got shot. Again, trajectory. Here, upwards, to the left, making perfect sense that he's running away. Not pointing. Not pointing. Like the defense wants you to believe. Remember the multiple times they tried to see with Dr. Durso, well, was he doing this and was he snaking and popping and locking? No, none of that was ever said. He was running, and when they tried to do that, he said, no, it's more consistent with the shooter being directly behind him. Folks, if he was turned in the direction that they want to believe, his spine would have been severed by that bullet. Common sense. You didn't leave your common sense in the parking lot when you parked today. You brought it with you. That again is why we went through that process. Some of you may think it was painstaking last week to sit you as jurors, because we wanted you to take the facts of this case, not Paul Harvey, not Steve Harvey, not some other Harvey, but the facts of this case that came from this witness chair. Not some stuff that's speculated or what we can kind of come up here and start trying to come up with about moonwalking backwards and all this kind of stuff. But none of that. The evidence that came from this chair. Did you hear that? Another witness. Jasmine Broadwater. Another vantage point. They're running directly to her. Did she say she ever saw a gun in Cyrus's hands? No. Did she ever say she saw Cyrus point? No. Never. Nobody with the last name that's not Chow says that ever happened. And interestingly enough, you saw in the video, after the shooting took place, we were walking around. Rick Chow. The officer had to tell him multiple times, stand still, don't touch evidence. I'm gonna charge you with obstruction, you keep messing around there. Move the gun, by the way. He and his family went to the store, came back, had plenty of time to talk about what they were gonna say. Plenty. But at the end of the day, when Andy sat up here, there was nobody to protect him from cross-examination. Nobody to protect him. There was conversation about a barrel. Andy says, I saw a silver barrel. Folks, I submit to you, there is a gun lock on here. This is not the condition of the gun. You'll see it on that video. The condition of the gun was this. That's a black barrel, right? Ladies and gentlemen of the jury, we talk about credibility and believability. Well, we'll get to that in a minute. One other thing that the esteemed cable said is that Cyrus Carmack-Belton, again, wandering the streets with a loaded pistol, empty book bag, no money. Now, I'll take this on myself because at the end of the day, I'm the boss. And I'm the person who at the end of the day gets the opportunity to say, hey, we need to bring this witness to that witness. So y'all blame me for this one. This is my fault. I will say this is my fault. Maybe we should have brought in another expert. Maybe a 10-year-old or a 12-year-old or a 13-year-old who could talk to us about the intricacies of cell phones. My gosh, maybe they could tell you that if you hit the right click button on an app. Yes. Sure. So maybe we should have had an expert to talk about apps on phones and the fact that in 2026, even back in 2023, you did not have to have cash in order to buy stuff. You can pay on. Maybe that should be an expert that we call next time, since they made such a big stink about those things. Folks, that wasn't pleasant, that actually required some type of thought process that may not go exactly how he rehearsed his testimony? Eyes. To the point to where he said, well, my counsel said I couldn't. You don't want to know what your counsel told you. But every time a hard question came, his eyes went from here to there. Folks, I was taught a long time ago, when you lie, you got to remember what you see, right? And if you lie about the small things, then you can't be trusted with the big things, to tell the truth about the big things. So think about that for a minute, because when we talked to Andy, there was a back and forth about simple stuff, like through versus dropped, right? Like pulled versus pointed, which again, no witnesses not named Chow ever said the word pointed. Like chase versus follow. Why are we having conversations about chase versus follow when you saw how fast they were going after? Folks, I may not be the sharpest tool in the shed, but to me, running after requires you to be going after something for a purpose. Example, as a kid, ice cream truck passes by the house. Ding, 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 ding. You miss it. You will go out the house and you run after the ice cream truck. Why? Because you want to catch it so you can get some ice cream. Simple. Or sitting, you wake up a little bit late for school and you hear the bus go by. You're missing the bus. You run after the bus. Why? so you can catch the bus and get on and get to school. Or maybe more recently, flying from Columbia to North Dakota. And there's a flight that first leg takes you to Charlotte, second leg takes you to Minneapolis. You get to Concourse A, your flight takes off in 28 minutes. What you gonna do? You're gonna run to Concourse C to catch the flight. Why? Because you don't want it to leak. You run with the purpose to catch. Folks, I ran after my wife for 2 years and I caught her. But do you think when I caught her, I said, hey, I want to give you directions about how to get to that dude so he can tell somebody else about something. Come on, folks. When you parked your cars, you didn't leave your common sense. They ran to catch. At the end of the day, what happened here is simple, and they don't want to admit it because it hurts. They ran after Cyrus emotionally. They were irritated. They were mad for whatever reason. They ran after him. They caught him. They caught up to him because he fell multiple times. They wanted to shake him down and get that out of the water and then figure out what to do with the police later. That's why they ran. That's the simple truth. That's the simple truth. That gun spilled out. And then that man made a rash decision. He overreacted. Andy saw the gun. He said gun, and he shot him. There wasn't all this time to back up. No witnesses even say that he's even backed up. They said they were advancing the entire time. Folks, don't let the defense rewrite the facts because the things they talked about didn't happen that way. They didn't happen that way. For over an hour, Andy sat on that stand and he said a lot of things. He said a lot of things. But did you ever hear the 2 words? I'm sorry. I'm sorry that I wrongfully accused this kid of stealing and chased him down the road. You know why? You didn't hear that? Because he's not. This is about product over people. This is about inventory. This is not about a person's life. Mr. Kent spoke about withdrawal. And he keeps trying to suggest that Andy Chow withdrew by doing this and coming backwards all this way and saying, hey, stop doing that, Dad, you gotta go. Nobody testifies that happened. He doesn't have the last name Chow. 4 people who don't know one another, who had to be subpoenaed to come to this court, spoke to you, and they never said that it happened because it didn't happen. He did not withdraw. They kept going forward. They kept going forward. And ultimately, this gun was never pointed. But folks, I suggest to you, even if it was pointed, he was running in the opposite direction. Opposite direction. That's what the evidence shows by the way he was shot. It was in the opposite direction, trying to get away. I'll say this. It's offensive to hear the defense keep trying to characterize Cyrus as this young thug. But it's equally offensive to then try to characterize Andy Chow as Mr. Rogers. Excuse me, Rick Chow, the defendant in this case, is Mr. Rogers. You know, the man who chased a kid down, shot him in the back. And then they want to say, well, he was trying to help, clean vomit out of his mouth to resuscitate him. Folks, that's offensive. Because the last face that this scared child saw as he ran away was that man peering over him. Peering over him. And none of this happens if they stay their behinds in the store and use that intricate camera system that picked up on every angle. Could see everything from what he wore, the type of shoes that he wore, the direction he went, everything. A couple seconds is all it would have taken, just like it did in the store, to say, hey, you know what, we were wrong. But they didn't do that because they were overcome with something. Maybe it was meanness. Maybe it was malice. Maybe there's some nefarious intent in their heart, a reason for them to chase him and shoot him in the back and end his life. But again, never the two words that matter most, and I'm sorry or I made a mistake. However, none of them, because they're not. I'll talk to you about a poem by Omar Khayyam called Rubra. And I told you that I would link it all together. The moving finger writes, and having writ moves on, nor all your piety nor wit shall lure it back to cancel half a lie, nor all your tears wipe out a word. Folks, that's a poem about time and how you can't erase what's been done. You can't go back and change what's been done. With all your piety, no matter how many degrees you got, how many doctorates you got, when you do something, it's there, it's done. You can't reverse time. You may try, you may get up here and get on the stand and try to think your way through it and reason your way through it. But at the end of the day, what they did was murder. So in a more literal sense, eventually we're going to be asking that your moving hands come back and write these words. Because Rick Chow is guilty of the murder of 14-year-old Cyrus Carmack-Belton. Now, folks, you're going to have a chance to deliberate in a moment. And as you deliberate, you will apply the facts, in this case, to the law that the judge is going to give you in a couple of moments. And as you do that, I'm asking, Dale Scott is asking, Stephanie Taylor and Weston Lee, for all of us are asking that you return a verdict of guilty in this case. I'm just looking to make sure that I covered everything that Mr. Kent covered. I ask you to think one last thing. I'm out of your face. We all know there are 50 states in the United States of America. But I think I've learned sitting in this trial that there are actually 51. There's the state of denial. The state of denial is where that man lives because he's denying that what he did was wrong. He's denying that he chased and killed that young child, Cyrus Carmack-Belton, who never pointed a gun at him. The witnesses tell you so. Not his son, who's got every motive, every reason to twist it around in order to protect his father. Denial that you, the jury, believe or will believe that what he did was wrong. Denial that at the end of the day, he believed that a human life was not more than that. Folks, it's for these reasons that the state of South Carolina is asking you to return a verdict of guilty, because Rick Chow is guilty of murdering Cyrus Carmack-Belton. Thank you for your time.
Thanks, Judge.
Take care.
Madam Corlady, ladies and gentlemen of the jury, you've heard the evidence and the arguments of both parties. Now I can explain the law to apply in this case. Maybe I'll do that in a moment.
Quiet, the building sector.
charges that I'm going to read to you will not be sent back to the jury room, so it's important that you listen carefully to the instruction. If you have any questions during your deliberation, I can bring you back out and explain the law to you again if you have specific questions about the law. Now, you and I have specific duties to perform, like we discussed from the outset. As a trial judge, it is my responsibility to preside over the trial. It's your responsibility to consider the testimony which has been presented from the witness stand and the exhibits introduced. I have the duty to charge the law applicable in this case. As presiding judge, I am the sole judge of the law, and it's your duty as jurors to accept and apply the law as I now stated to you. If you already have any idea as to what the law is or what the law ought to be, and it does not agree with what I tell you, the law is you must abandon your idea because you are sworn to accept the law and apply the law exactly as I stated to you. Your duty is to determine the facts. In every case, the jury is the sole and exclusive judge of facts. A trial judge cannot suggest, state, comment on, or make any statement to a trial jury about the facts in the case. Since you are the sole judge of the facts, you are not to infer from what I have said during the progress of this trial and ruling upon the admissibility of evidence or otherwise, or anything that I say now during the course of this instruction to you, that I have any opinion about the facts in the case. The law does not allow me to have an opinion about the facts. This is a matter solely for you to determine. As jurors, it is your duty to determine the effect, value, and weight of the evidence presented during the trial. The indictment charges the defendant with murder. The fact that the defendant was arrested, charged, and indicted is not evidence and cannot be considered by you as evidence of guilt, nor does it create any presumption or inference of guilt at all. This indictment is simply the formal written instrument which contains the charge made against the defendant. It is the formal document by which this case is brought into this court and gives this court jurisdiction. The defendant has pled not guilty to the indictment, and that plea puts the burden on the state to prove the defendant guilty beyond reasonable doubt. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is a guiding rule of law that the defendant in a criminal trial, no matter how serious the charge, is always presumed innocent of the crime for which the indictment was issued unless guilt is proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the defendant's guilt beyond a reasonable doubt. The presumption of innocence is not mere legal theory. It is not just a legal phrase. It is a real and substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. What is reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. The state has the burden of establishing every fact necessary to prove the defendant guilty beyond a reasonable doubt. The law presumes every person charged with a crime to be innocent, and the burden of establishing guilt is placed solely on the state. The defendant is not required to prove his innocence. Some of you may have served as jurors in civil cases where you were told it's only necessary to prove that a fact is more likely true than not true, such as by the greater weight or preponderance of the evidence. Other civil cases use the clear and convincing standard. In those cases, it's necessary to prove that a fact is highly probable. But this is a criminal case, and the state's proof must be more powerful than those burdens of proof. In criminal cases, the state's proof must be beyond a reasonable doubt. Proof beyond reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. The defendant is not required to prove his innocence. If, on the other hand, you think there's a real possibility the defendant is not guilty, you must give the defendant the benefit of every reasonable doubt and find him not guilty. Necessarily, During your deliberations, you must determine the credibility of witnesses who have testified. Credibility simply means believability. It is your duty as juror to analyze and evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in the case, you may believe one witness over several witnesses or several witnesses over one witness. You may believe part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety or reject the testimony of the witness in its entirety. You may consider whether any witness has exhibited to you any interest, bias, prejudice, or other motives in the case. You may also consider the appearance and manner of a witness while on the witness stand. There's been evidence presented that witnesses have made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use the evidence of the earlier contradictory statements to determine the truth of those statements. It's up to you to decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all testimony of that witness or give all or part of the testimony the way you think it deserves. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. Criminal intent is always a matter that must be determined by the jury from the circumstances existing at that time. There's no way to prove intent to a mathematical certainty. There's no way medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances showed to have existed. This is how you make a determination of whether or not the element requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact, taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state of conscious wrongdoing. You must determine what the defendant intended to do based on the circumstances existing at that time. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty, or to consequences that are considered by the law to be the equivalent of criminal intent. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of the fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of the fact. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If the circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has a burden of proving the defendant guilty beyond reasonable doubt. This burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. As I mentioned to you during the trial, the rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witness. A witness who, by education and experience, has become an expert in some art, science, profession, or calling, may state an opinion as to relevant material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you're not required to accept an expert's opinion even though it is not contradicted. I instruct and emphasize to you that the fact that the defendant did not testify is not a factor to be considered by you in any way in your deliberation and in your consideration on the question of the guilt or the innocence of the defendant. It must not be considered by you in any manner whatsoever. I repeat, under your oath, you are to draw no conclusion whatsoever from the fact that the defendant did not testify. The fact that the defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated to you, is on the state. The defendant is not required to prove his innocence. The burden of proof remains on the state to prove guilt beyond a reasonable doubt as to the charge against the defendant. The defendant is charged with one count of murder. The state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exist for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the evil intent and the act. Malice aforethought may be expressed or inferred. These terms express and infer do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when a person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or of any other act of preparation going to show that the deed within the defendant's mind would be expressed malice. Malice may be inferred from conduct showing a total disregard for human life. If facts are proven beyond reasonable doubt sufficient to raise an inference of malice to your satisfaction, this inference would simply be an evidentiary fact to be considered by you along with the other evidence in the case. And you may give it the weight you decide it should receive. The defendant has asserted defense of others as a defense to his prosecution. Under the law of self-defense, the defendant may take another's life in defense of others. The right to intervene to protect another person is subject to the same rights and limitations as the right of self-defense. The defendant may take the life of a person who assaults a friend, relative, or bystander if that friend, relative, or bystander would have had the right of self-defense. Defense of others is a complete defense, and if it is established, you must find the defendant not guilty. The state has the burden of disproving defense of others by proof beyond reasonable doubt, and the burden is carried by disproving any one of the four elements by proof beyond a reasonable doubt. If you have a reasonable doubt of the defendant's guilt after considering all of the evidence, including the evidence of defense of others, then you must find the defendant not guilty. On the other hand, if you have no reasonable doubt of the defendant's guilt after considering all the evidence, including the evidence of defense of others, then you must find the defendant guilty. The following elements are required to establish self-defense, and in this case, defense of others. First, to show that the person being defended had the right to self-defense, it must first be shown that the person being defended and the defendant were both without fault in bringing home difficulty. If the conduct of the person defended or the defendant was the type which was reasonably calculated to and did provoke a deadly assault, the person would be at fault in bringing home difficulty and would not have the right of self-defense. Therefore, the defendant would not have the right to use deadly force in defending that person. One's right to self-defense or defense of others is restored after a withdrawal from the initial difficulty with the victim if that withdrawal is communicated to the victim by word or act. Withdrawal from a conflict must be effectively communicated to the victim by word or act to restore the right to use self-defense or defense of others. An accused who provokes or initiates an assault cannot claim self-defense or defense of others unless the person defended both with withdraws from the conflict and communicates his withdrawal by word or act to his adversary. Second, the defense of another person is excusable if the defendant had reasonable grounds to believe and in good faith did believe that the person being defended was in imminent danger of death or serious bodily harm from the victim. In deciding whether the person defended actually was or that the defendant actually believed the person was in imminent danger of death or serious bodily injury, you should consider all the facts and circumstances surrounding the crime, including the physical conditions and characteristics of the parties. The defendant does not have to show that the person defended was actually in danger. It is enough if the defendant believed the person was in imminent danger. The defendant has the right to act on appearances, even though the defendant's beliefs may have been mistaken. A third element of self-defense requires the defendant to show that under the circumstances as they appeared to the defendant believed the person defended was in danger, and that a reasonably prudent person of ordinary firmness and courage would have had the same beliefs under the same circumstances. It is for you, the jury, to decide whether the defendant's fear of immediate danger or of death or serious bodily injury to the person defended was reasonable and would have been felt by an ordinary person in the same situation. The defendant does not have to wait until the victim inflicts harm on the person defended. The defendant has the right to act under the law of self-defense of others, to prevent the victim from inflicting harm on the person defended. The final element necessary in order to be entitled to defend another requires that the person defended have had no other probable way to avoid the danger of death or serious bodily injury than to act as the person defended did in this particular instance. Where the person being defended had no duty to retreat, the defendant likewise would have no duty to retreat. The defendant had no duty to retreat if by doing so the danger to the person defended of being killed or suffering serious bodily injury would increase. When considering defense of others, the relative sizes, ages, and weights of the parties may be considered in deciding the apparent or actual need for force in defense of others and the amount of force needed. A person cannot be required to make an exact calculation as to the degree or amount of force which may be needed to avoid death or serious bodily harm. Therefore, in defense of others, the defendant has the right to use the force needed to avoid death or serious bodily harm to the person defending. Force used in defense of others does not have to be limited to the degree or amount of force used by the victim. The defendant has the right to use so much force as appears to be necessary for complete protection of the person defended, and which a person of ordinary reason and firmness would have believed to be needed to prevent death or serious bodily harm to the person defended. Where a person inflicts an injury or death on another person, he must be convinced beyond reasonable doubt that the defendant's actions were the proximate cause of the victim's injury or death. Proximate cause is the direct cause. It is that immediate cause. It is the efficient cause. It is that cause without which the injury to the victim would not have resulted. There must be a chain of causation from the defendant's actions until the time of the victim's injury or death. Proximate cause does not necessarily mean that it occurred immediately prior to the injury or death. There may be more than one proximate cause. The acts of two or more persons may combine together to be a proximate cause of the injury or death of a person. The defendant's act may be regarded as a proximate cause if it is a contributing cause of the injury or death of the victim. The fact that other causes also contribute to the injury or death of the victim does not relieve the defendant from responsibility. The defendant's act need not be the sole cause of the injury or death, but must be a proximate cause contributing to the injury or death of the victim. Negligence on the part of someone else would not relieve the defendant from criminal responsibility if the actions of the defendant were the proximate cause of the victim's injury or death. Ladies and gentlemen, I declared the law to you through these instructions to help guide you to a verdict. Whether some of these instructions apply depends on what you find to be the facts. The fact that I instructed you on various subjects in this case should not be taken as indicating an opinion of this court as to what you should find to be the facts or as to what your verdict should be. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree. The verdict must be unanimous. All 12 of you must agree on the verdict. The verdict cannot be based on sympathy, passion, prejudice, emotion, or any other consideration not in evidence in the case. Disagreements may arise during deliberations and your debates may become spirited. I urge you to be courteous and to one another and respectful of your fellow jurors' perspective as you work toward a verdict. Remember, at all times, you are not partisans favoring one party over another. You are the judges of the facts. Your sole interest is determining whether the state has proved the defendant's guilt to the charges beyond a reasonable doubt from the evidence presented to you in this case. Again, ladies and gentlemen, your verdict must be unanimous. Now, before when the jury agrees on the verdict, you will fill out the verdict form, which I have here. It's very self-explanatory. It will go back to the evidence. After you reach the verdict, Madam Board will fill out the verdict form and sign. And knock on the jury room door and inform the bailiff you have reached the verdict. At that time, we'll receive you back to the courtroom. We'll ask you to return to the jury room and not begin deliberations until you're told by the clerk or the bailiff to do so. There are a few more matters of law that I need to discuss with the lawyer before you begin your deliberation. All right, so I'm going to ask you to help back. I believe your lunch is already here. So y'all can get started with that. We'll be with you very shortly. I'm going to ask the alternates to please stay with us. Exception to the charge of mistake.
None, Your Honor.
Any exception from the defendant?
Your Honor. Judge, can you indulge us one moment? I need to find something. All right. Give me a minute.
While y'all are working on that, our alternates, you are now excused. You do have lunch back there. But thank you for being here again. Like I said from the outset, we can't do our job without folks being able to show up. This is very, as you can see, these days, a very important job. So again, thank you for being here. You are excused. I've always told you, you certainly have the right to discuss your observations with the lawyer. Sometimes the lawyer would like to see input. You do not have to. If anyone contacts you in any way about this case, and you feel uncomfortable about it, you call back into the clerk's office and I will take care of it. But you're free to discuss the case with anyone at this point that you see fit. Again, you certainly have the right not to discuss it with anyone. Again, thank you for being here, and maybe we'll show you that.
Well, then converse, maybe we start to go through the exhibits to expedite matters first. Thank you.
Quiet, please.
I would like to just go ahead and, as to the elements of self-defense, I believe Your Honor charged. With respect to the self-defense charge, it's up to the defendant to show these various elements of self-defense. And of course, you also said it was a burden of proof on the state to disprove those elements, or any one of them. And I'm just would like to put on the record, I think that may be burden shifting as to this defendant being required to show, and sort of contradicts the defendant to rely on the state's failure to prove those elements. So I just want to go ahead and put that on the record that I think that may be error, and I would be off.
Well, I guess my question to you, how would the state prove something that the defendant never showed?
Well,
I don't know how else to describe it. I mean, I understand what you're saying.
yeah, it just troubles me because I taught a lot of self-defense cases, but I just don't remember the charge being exactly like that. Where
I have not changed it in the 4 years I've been. Not saying I'm right or I'm perfect, but that's what has been in the standard charge.
And I understand. I just want to, if down the road the court decides that is burden shifting, I just want to be on
You are on the record and that is certain possible.
the record. That's the extent of the argument.
Okay, otherwise no other exception.
No,
Only subject to our original request, Your Honor.
All right, are the exhibits ready?
Not yet, Your Honor, we're just going back and making sure there's a clean copy of the state's 7 goes back. There was, I'm sorry, defense 7. There was Carter and the defendant, Mr. Chow. We just want to make sure that's the clean copy. The proper copy of that. And we're just going through the count right now, Your Honor. So we'll move quickly.
Can I write a couple things down?
All right, don't slow down.
Check, 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 1, 2, testing.